Hello everyone, welcome back to my latest video. Today I would like to talk about an important act called the Contempt of Courts Act 1971. So we all are aware of our fundamental right to freedom of speech and expression, which is the bedrock of our democracy. Every one of us has the full right to express our opinions and views on any subject matter and make it known to the general public at large. However, when it comes to the judicial system, it is essentially like walking a tightrope. On the one hand, we do have the right to express an opinion on the way the judiciary functions, and on the other hand, it is also a responsibility to ensure that it does no malicious contempt, as in no criticism, no unwarranted, no destructive criticism of the judicial system happens in such a way as to undermine the system, so as to undermine the fact that the judicial system functioning is what keeps the country functional. The judiciary essentially upholds the laws of the country and keeps a check on the other two branches of power in the country, namely the legislature and the executive. These two legislature pass the laws, and the judiciary regulates those laws to ensure that the other two branches don't pass unnecessarily oppressive laws or exercise too much power to oppress the public. The judiciary kinda safeguards us. But there are people who are known to pass unwarranted, unjustified criticisms of the judiciary, which, if not checked, could potentially end up harming the judicial system. And courts are very strict about this. They punish unwarranted criticism of the system, of the judicial system, very harshly. Well, not very harshly, but somewhat harshly. This system of punishment for such unwarranted criticism, or shall we say contempt of court, to use the official term, was laid down under one act called the Contempt of Courts Act 1971. So let us explore further now on about this act. So as I said earlier, this law, the Contempt of Courts Act, it aims at safeguarding the judicial system from unwarranted attacks, from malicious, destructive attacks, which would aim at undermining the judicial system and undermining thus the legal security of the country. So we'll cover first the core definitions of concepts pertaining to this act. Then there are some exemptions. Basically, this law is provided for certain acts which are exempt from punishment under this act. Then what constitutional authority has this? What authority has this act derived from the Constitution? Then we'll analyze some important case laws. Then we'll also examine what are the rights of the people under this act, and if contempt of court happens, what is the defense available. So this act was established on 24th December 1971. It was enacted. So the thing we need to understand is court proceedings are pretty sensitive and delicate. They concern important matters of law, or even important matters relating to parties who were taken into dispute. So unnecessarily trying to undermine the courts, undermining the judicial system, in order to prevent all of that, this act was enacted. Essentially, this act says that you could criticize the courts and all if you want, but there are limits. You can't exceed those limits, and the act has specified those limits. So when it comes to contempt of court, or undermining the court system and all, this act has imposed several penalties for it. One penalty is, if you pass an unwarranted criticism of the court, or of a judge, or any legal officer, in such a way that the functioning of the system is undermined. Let's say if a case is going on and you attempt to do something or say something to undermine the proceedings of the case in the court, then you are punished for that. Punishment one includes imprisonment for max up to 6 months. It could be less also depending on the severity of the contempt matter. So sometimes it's just for a couple of days, maximum 10 days or less than that. But the law says that maximum imprisonment for 10 for contempt of court is only up to 6 months, not more than that. Then you're if you are found guilty of undermining the court system, then the unjustly undermining the court system, you are also required to pay a fine of up to maximum rupees 2000. This is of course maximum amount. It could be lessened depending upon the severity of the offense, as the court would decide if a contempt case is brought before it. Then there are two types of contempts. One is civil contempt, one is criminal contempt. As it happens for civil contempt, there is even a special prison called a civil prison which has been built to contain such kind of offenders. So in case of in civil cases, if a court gives an order and the parties don't comply with it for any reason or for no reason at all, then they are obliged to be detained in a civil prison for max up to 6 months, like I said earlier. Then now coming to the nature of contempt of court, there are two types of contempt. One is civil contempt and the other is criminal contempt. Now what is civil contempt? Civil contempt means when a case is going on, let's say there is a case of uh, loan default going on in a court, and the court after a couple of proceedings has passed an order telling the defaulting party to pay some compensation or repaying some amount of the loan to the aggrieved party, but the aggrieved party simply refuses to comply with the order for no good reason or for any reason. And if the court decides that, and such willful disobedience of what is what is an order or decree passed by the court or a judgment, that is called a civil contempt. Essentially, if the court passes an order in a civil case and one of the parties just refuses to obey that order and doesn't have a good reason for such disobedience, that is a civil contempt. Criminal contempt would be, this is the second type of contempt. Now this type of contempt is even more serious. Now this in this type of contempt, the one of the parties in a case would perform an act which would scandalize the court, as in outrage the court. If there is a court going on and if the court proceedings are disturbed for without any good reason, or if proceedings are going on and if you try to manipulate the proceedings in your favor in such a manner that the natural course of the proceedings is disturbed for any reason, or if you attempt to do anything outrightly outrageous in such a way that the course of justice is itself obstructed, as in if the proceedings were going normally without any interference and the court would have delivered one verdict, but you did something or attempted to do something. Let's say you attempted to bribe, if you, let's say you were a defendant and there was a prosecution witness you found out about and you attempted to bribe him, or let's say you knew some of the judges and you attempted to write threatening letters to them, threatening them with consequences if you did not if the judgment was not passed in your favor and all. Essentially all of that is disturbing the natural course of justice, disregarding the rules of evidence that apply to the court and all. So all of this constitutes criminal contempt. Essentially, to put it in short, criminal contempt is not just refusing to obey court orders, it is literally disturbing, are literally attempting to undermine the court itself, to disregard the court itself, to uh, essentially try to control things happening in the court in your favor in an extremely heinous manner. That is criminal contempt. Now, why two? Now, obviously, one contempt would have been enough, right? So, why this classification? This classification is to essentially ensure the nature of contempt. You have to, even though plenty of parties do indulge in contempt of court, the degree of offense is not always serious. It could be some minor, it could be sometimes pretty major, it could be sometimes very, very bad. So, this classification has been made that way. What happens is, because that way the judiciary lets others know that even if criticism of itself is allowed, unjust criticism is not so allowed. And also, even if contempt were to happen, the court knows that the judiciary tells the public by this classification that it can understand that not all offenses are severe, that it is willing to be lenient in some cases and not so lenient where it is deserved. So that way, the public's confidence in the judicial strength and judicial fairness is kind of strengthened by this classification. Now, moving ahead, now what is civil contempt? Like I said earlier, civil contempt is essentially refusing to obey an order of the court, whether it be in the form of a written decree or a judgment after all the proceedings of a case are over, or any interim order that was passed during the proceedings. So, civil contempt is essentially, to put it very simply, it's refusing to obey any order that the court has passed during or after the case is over. So, so what is the so why this type of contempt was classified? Now this is not now I have stated in an earlier slide that contempt is usually punishable with 6 months imprisonment or 2000 rupees fine. However, civil contempt, the judiciary has classified this type of contempt to tell everyone that this type of contempt need not always be so drastically or at least so badly punishable, that there is a simple way to remedy this sort. That is, the court would use whatever means it has at its disposal, legal means, to force a disobedient party to obey its orders. That's about it. Essentially, if the other party is aggrieved and the defaulting party is not obeying orders, the court could use this sort of rod to force the other party to comply with its orders. Something like that. That if it does not obey the orders, if it continues to defy orders, then that punishment will come. Otherwise, if the defaulting party does not want that punishment, all it has to do is obey the court's orders. That's all. Then criminal authority contempt, like I said, the civil contempt was pretty mild, or it was essentially disobeying orders of the court, kind of like a kid disobeying a parent or something, or a teacher. So that is easily remedied by forcing compliance. But criminal contempt is much more severe. This is essentially like if you went farther than disobedience, if you attempted to literally attack the court's existence or the court's authority, if you attempted to undermine it in a much more serious manner, that is what is criminal contempt. So there are three ways to criminal contempt is done. One is by scandalizing the court. And how is this done? This is done by, let's say, if there are in a court there are certain proceedings happening and the court directs that those proceedings are to be kept strictly secret, especially if those proceedings are not happening in public but in camera. That is, instead of the general public attending proceedings, there's just a camera put inside the court which records the testimony of the witnesses and the proceedings going on. If those proceedings are published despite the orders of the court, or if any act is performed, let's say you write threatening letters to the preceding judges, or you threaten the opposing advocates of the other party, or really anything that would ensure that that the court is undermined, that the proceedings are essentially manipulated in your favor, or rather the other, or everybody else in the court is coerced to do your bidding, that is scandalizing the court. Then prejudicing proceedings, this is also same as scandalizing the court only. This is mostly like, let's say if you attempt to bribe witnesses who are likely to testify against you, or like I said earlier, writing threatening letters to judges, or attempting to manipulate proceedings in your favor unjustly, that is prejudicing proceedings. Then obstructing administration, this is essentially going way beyond even the other two. This is you literally attempting by force to either stop the proceedings or ensure that the proceedings will come in your favor no matter what, or attempting to stop the proceedings by threatening, by ensuring that a key piece of evidence is deliberately missing or not put forth in the court, or anything like that. So essentially, or ensuring that, or as essentially all of this constitutes obstructing the natural course of justice. Obstructing, if a proceedings were happening without interference, what would have been the probable outcome, and you attempting to manipulate that outcome, or ensuring that the proceedings don't happen at all, or threatening the other party that if they take it to court something bad would happen to them, all of that is obstructing justice. So how you can initiate a contempt case in the court? There is a detailed procedure for this. Number one, so one act, either an act of either disobeying court orders, or as I said before, criminal contempt of court, that is undermining the court's authority, undermining the natural course of proceedings and all that. Some sort of act has to occur in the court or has to be detected by the court. Then once the court finds out about it, or something happens right in front of it, so the court would take suo motu notice, that is without any move on either of the parties part, the court itself decides to take action on its own. Or if a party believes that the court's authority has been disregarded or its orders have been disobeyed, the party itself can file an application. This has to be done with the consent of the Attorney General, the AG, most of the time. Then once either the court itself takes the initiative or the party files an application, the court would later on issue a notice to the defaulting party or the accused party, the condemner, so to say legally. The notice would tell the other part, basically it is like a show cause notice, something like how in income tax, GST, if you don't pay tax, the income tax department sends you a show cause notice asking you to pay the tax or asking you to pay penalty, and asking for reasons as to why you are not obliged to do so. Similarly, here also the court would present a show cause notice to the accused party telling them why they should not be punished for their misbehavior. Then just like in any other court cases, here also the court would conduct a hearing for the accused party. The accused would be allowed his own counsel. He would be allowed an advocate to defend him for defense and all. Then the evidence that the party has to present in order to be cleared is mostly that the criticism was just that the criticism was completely fair and it did not unnecessarily undermine the court, and that even if it did do so, it was in the interest of the public, that the public benefited from what the condemner did. The condemner has to show clear proof of all that. Then after all that, after the hearings and all, then the court, just like in a normal case, would pass a judgment, either acquitting the accused party or punishing him with fine or imprisonment, or both, as I stated earlier. However, like I also said earlier, there are exemptions provided under this act. That there are certain acts which are not regarded as contempt of court. These acts will not be punished even if it is brought before the court. And one is the section 3 of this act provides for innocent criticism. What happens is, let's say that you were a witness to the proceedings of a court, and you didn't have any idea that those proceedings were to be kept secret, or that they were still ongoing. Most of the time what happens is, when cases are ongoing, you are not allowed to publish the proceedings of the case. You can only do so once the case is done and over and done with. However, if you somehow believe they were over and done with, but in fact they were not, that the court had merely, let's say, postponed the case or adjourned it, but you mistakenly believed that in good faith that the proceedings are over, and you chose to publish it anyway. So, if the case is taken before the court for contempt, and you are able to prove sufficiently well that there was no reason for you to believe that the case was still pending, that it wasn't over, then you cannot be punished for contempt. Then another exception is under section 4. It's called fair criticism. That is, if a contempt case is brought before you and you are able to prove to your benefit, you are able to provide solid proof that the criticism of the judicial proceeding report you gave was impartial, fair, and substantially correct, that you did not attempt to cast any undue suspicion or aspersions on one of the parties, or even on the presiding officer or judge, without good reason, that you only wanted to essentially you are just like recording the proceedings as it happened, without passing any undue judgment, then also the court is obliged to let you go. It's not contempt. Then under section 5, this is basically, if a case is done over and done with, and long after the case is over, you analyze the case. You publish a critical analysis of the way the case went on, but because the case is over, and so it does not affect the outcome of the case in any manner. So that way, even if a case is brought for contempt, the court will let you go, because a case is already over and done with. Even if you criticize the way the case was handled, it will not affect it in any manner. So again, the court would let you go. Then under section 6, when it comes to subordinate courts, there is a thing called under high court there are subordinate courts like sessions court and district court. Now most of the time contempt cases are usually presented to the high court against anything that happened in the subordinate courts. However, if you had genuine grievances against the presiding officer or judges of the subordinate court, and you filed a complaint and all, then also the court, if the high court decides that the complaint was fair and just, and that it was made properly, then also it's obliged to let you go. Now, when it comes to section 3 and 6, as even 4 also, the grounds are a bit sketchy. Largely, there have been criticisms made by reputed judges stating that courts have been known to abuse their powers provided under this act to punish any criticism of itself or any criticism of judge. Sometimes even judges, they use this act to unduly punish lawyers who try to talk back to them or something. So these 3 grounds are a bit sketchy, bit muddy. So my advice is to be somewhat careful. Try not to cross a judge or any officer or advocate senior to you unnecessarily, if you don't want to jeopardize your career as a legal professional. Or if you are a member of a normal public, just be sure to respect the authority of the court. Try not to unnecessarily challenge it. Then section 5. As I said earlier, section 5 relates to protecting fair criticism. This is especially when it comes to courts, this is especially when it comes to analysis, critical analysis of a case after it's already been decided, after it's over and done with. So this section protects such sort of analysis being made, since of course it's important. Once a case has happened, such critical analysis can actually be helpful when similar cases are conducted in the future, so that they are conducted better, more properly, in a much better manner, and to ensure better administration of justice. So this section is to ensure that such potentially beneficial critical analysis of past cases are not unduly punished by the courts as contempt. This section essentially exercises a check on the power provided by this act to the courts. So this section means that journalists and legal scholars, that is seasoned lawyers and all, for the benefit of those of us who are law students or those of us who are aspiring to make a career in the legal arena, for the benefit of all of us, critical analysis of past cases are published and discussed freely. That way, those of us who are new entrants in the legal field, or those of us who aim to make good careers, can learn from such analysis, can learn how to conduct cases in the future more properly, and it can help us in substantial preparation. You could say that this is, you could even use the judgments from such cases in similar cases as a reference point to strengthen your own arguments or pleadings when you are fighting in the court. So yeah, this section also ensures that the judicial system is protected, but at the same time, not just the system is protected, but public confidence in the judicial system remains. This section aims to tell people that this act only aims to preserve the judicial system and prevent it from being undermined. At the end of the day, this section aims to prevent abuse of power by individuals in the system. Essentially, this section aims to assure the public that individual members of the system, whether it be judges or officers, they are not immune from criticism. It is the system which is immune to unjust criticism. At the end of the day, even judges can be held in contempt of their own courts. This section is such that it aims to punish even judges should they attempt any contempt of even their own courts. So that's how it is. Then contempt laws have evolved now. This So how did it evolve? Number one, in 1950, shortly after our independence, what happened was, basically before independence, there were some courts which were established by the British. But if you are not satisfied with the courts in the British times, you had to go all the way to the Privy Council in England, which obviously a lot of our fellow Indians couldn't afford. Poverty was extremely rampant back then. So after independence, as a measure to, especially after India became a republic, as a means to sever ourselves from the English legal system, where the Constitution of India under Articles 129 and 215 established the Supreme Court in Delhi as the governing body for all of the courts in India. Then it established a high court for each state in India to govern the courts present in that state. So essentially, both of these courts were established as courts before which contempt cases could be passed. The Supreme Court can actually preside over cases of its own contempt, and similarly the High Court can do so not just for its own but also for contempt of subordinate courts. Then after 2 decades or more so after these articles, in 1971, the Contempt of Court Act was passed. This act defined, this act formalized the concept of contempt. It formalized the offences classified as contempt and procedures for taking these cases, sort of cases, to the court. Then in 1991, there had been a judicial case. There had been a case called Delhi Judicial Service case, where what happened was there had been a judicial magistrate who had been unjustly treated by police officers, that his authority had been undermined. Apparently these officers were not issuing warrants or summons properly, so he had attempted some action. As a result, the police unlawfully arrested him and humiliated him in public. So in 1991, in response to this, the Supreme Court punished those police officers and reaffirmed protection for judicial officers to ensure that their authority is properly implemented and the legal system is properly protected. Then in 2006, there was this, the Supreme Court, the Parliament then amended Section 13 of this Act to ensure that if, for instance, a contempt case was brought before you, then you were allowed to say that you passed a judgment in defense, that passed a judgment defense. Oh, sorry, let me amend this. That if your case of contempt was brought before you and you are able to plead in your defense, you are able to give solid proof that you are only stating the truth of the matter, that you didn't really attempt to undermine anything or anybody, but that you only wanted to present the truth of the matter for the benefit of the public and all, that defense could be allowed, that could be allowed as a valid defense in a contempt case. Then the Constitution of India, under Articles 129, 215, it has granted authority to the Supreme and High Courts to punish the contempt of themselves and of subordinate courts. Under Article 129, Supreme Court has been established as a court of record to punish its own contempt. If anybody, since the Supreme Court is pretty much the governing body for the legal system in India, and any decision made by the Supreme Court is pretty much final in our system. So any contempt of Supreme Court is essentially, the Supreme Court would regard it as undermining the entire system in India. So the Supreme Court has been given full authority to punish its own contempt. Then under Article 215, same sort of authority is given to high courts to punish their own contempt as well. Then under Article 142 sub-article 2, the Supreme Court has been empowered to give any order to punish its own contempt. Obviously, because the Supreme Court is the supreme authority for legal bodies, so any contempt of itself, if left unpunished, could severely undermine its authority and its supremacy. So the Supreme Court has been given full powers to punish its own contempt. Then under Section 12, this section does provide for punishment for contempt. At the same time, it also provides for a formal apology that could be rendered to the court if you committed any contempt of it. So one punishment is a simple imprisonment of max 6 months. This is especially if you did something against the court, but it wasn't a particularly bad one, like say a simple order that you disobeyed and all, then this is just simple imprisonment, nothing very severe. Then at the same time, you are given the right of tendering a sincere formal written apology to the court for contempt. Especially in civil contempt, this is the case. In civil contempt, if you disobeyed an order, but you apologize to the court formally in writing and promise to obey the orders, then the contempt would be cancelled. You could say the court would withdraw the contempt case. Now, this depends upon, of course, when it comes to apology, the court would also take into account just how sincere you are in your apology. If you have committed such contempt acts in the past, like if you have a history of contempt and all, the court might choose to disregard your apology and punish you with imprisonment anyway. So make sure that you have a clean record before you tender an apology, should a contempt case come before you. Then it other sort of the amount of punishment that is imposed, it depends upon what sort of contempt you have done. Let's say if you have done if it is just a simple disobedience of order, then the punishment will not be so bad. A modest amount of fine and imprisonment will not even be 6 months. It could be less than that, like say 10 days or 7 days or something like that. But if your contempt act is such that the outcome of a case is manipulated in your favor, or you attempt to coerce the court into cancelling the case and all, then that is a very severe contempt, which and for which the punishment might exceed 6 months. So again, it depends on case to case and on the type of act you did, just like how it is in criminal law. Then in 2006, like I said earlier, under section 13 subsection B, the parliament had amended the law to in such that if there is any proceeding for court of contempt, if a court is hearing such case, and if the court has evidence and decides that whatever that even if you are doing contempt of court, you are not really undermining the court's authority unfairly or unjustly, that you just wanted to present the truth as it was, that you only wanted to tell everyone how things really are, that you just wanted to ensure that the public was benefited in some way by your act, that you did it in the public interest, that you only attempted to expose the truth about a certain matter because the truth helped the public. Then the court would allow such sort of defense, and you could even get acquitted out of contempt, or at least get a much lesser punishment than you would have gotten earlier gotten in if the contempt or case was or not in justified, or essentially if it wasn't truth in public interest. If it was just malicious disobedience or contempt for your own benefit, then the punishment will be more severe. If it is truth in public interest, it would be either mild or there could be no punishment at all. That's how it is. So again, why does this law matter so much to the public? Now, obviously, advocates and they indulge in this contempt all the time. But at the same time, why is this act so important to the general public also? Now, there is a legal rationale. So what happens is you have to, in a democracy, institutions are established and interconnected, and checks held on those institutions and on individual people to ensure to prevent abuse of authority either by an institution or by individual people. That way our democracy remains. So what happens, let's say there is no contempt of court act, if courts allow their contempt to just pass unchecked, unpunished. So what happens is if the court's authority is continually undermined, it would be that people would cease to regard the court's authority altogether. They might attempt to take law into their own hands. They might decide that any judgment the court passes is not valid, is not that it could just be plainly disregarded, and nothing would happen. So what happens is court's authority would weaken, and later on people would cease to trust in the judicial system. So that way what would happen is people would start to take the law into their own hands, resulting in more acts of injustice and all. As they say, one act of injustice, if left unpunished or unchecked, could multiply and until it becomes a chaotic situation. So, which is why it's important to know. People often seem to think that this law is just about protecting judges, and it is agreeable. Judges, or if their egos are hurt, they often attempt to punish insubordinate lawyers and all, or people they deem below them by using this act to just punish for any matter. Even a simple criticism, if the judge could decide is completely unfair, is essentially under Contempt of Court Act punishable. So essentially judges who are, it is presumed, would abuse this law, and it happens a lot of times. But at the same time, like I said earlier, even judges are not immune from this law. Even if judges commit contempt of their own courts, they can be punished for it. So this law isn't really about judges. This law is mostly about your own right. That if the Contempt of Court Act is there, the courts would ensure any unnecessary, to prevent any unnecessary breaches of its authority, to ensure that its authority remains, that it is not unduly undermined. That way, people would know that court's judgment, court's decisions carry the weight of law, and that they are authorized, that they are full, they have strength in them. So that way people will not be tempted to regard courts as a mere sideshow and just do whatever they want, to take the law into their hands, to implement their own measures to resolve disputes, which could make things even worse. Which is what the judiciary standard says, that unless the contempt of court is not punished, judicial decrees would be mere paper tigers. Essentially, it is just like the same thing. Let's say a currency note. By itself, a currency note is nothing. It's just a piece of nicely colored paper. But what gives that currency note weight? What gives us confidence that that note, when exchanged, would is of value, that it would give us the goods we want? Simple, because it is regarded by all of us as such, that there are laws giving that paper value, that there are laws, that there is a substantial gold reserve in the country which gives that piece of paper sufficient value for it to be exchangeable. That is why reckless printing of paper money is very hazardous. It could cause inflation and all, just like how it happened in post World War I Germany, where law where there had been where because of the government's reckless printing of paper money, especially during the 1929 recession, not recession, more like 1929 depression, what had the value of money had become almost worthless. In fact, for buying a simple piece of bread, people used to carry cartloads of notes. That was how worthless it had become. But I'm digressing. Coming back to this point, the Contempt of Court Act ensures that courts have sufficient force behind them to ensure that punishment is rendered to people who unnecessarily try to undermine courts, and that whatever decrees they pass, they have weight, they have value, that people would regard them and people would obey them. Without this contempt of court, judicial the decrees and orders written on paper would be just that, pieces of nicely printed paper, but no value, nothing, nobody would regard them. And what happens when such pieces of paper, such orders are not regarded? It means that the law itself is not held in value, that nobody would regard the law anymore. So people would start to implement their own forms of vigilantism. They would try to take the law into their own hands. They would try to do things their own way with disastrous consequences. So the rule of law would collapse, and the rule of law does matter. It is true that the law is pretty slow, that cases take months or years, often with frustrating results, and it results in frustration for everyone involved. But the rule of law does matter. Without the rule of law, there is no order in the country. It would be chaos and all. People would want to do things their own way, and everybody has their own ideas. So those ideas, so there would be no common regard for anything. It would essentially be a horrible situation, which is why the rule of law is somewhat buttressed by a law like this. So it's important. So let's go over some case studies. One of the prominent cases in 2020 involved that of a lawyer, a very prominent lawyer named Prashant Bhushan. I think this had happened, he was a Supreme Court lawyer. So what happened was he had posted some tweets. In those tweets, what had happened was he had written what had these tweets, apparently they had unjustly criticized the Chief Justice of India and the Supreme Court itself. Now obviously when it comes to Supreme Court, as I said earlier, the Supreme Court is very strict on contempt of itself. Since the Supreme Court is the supreme legal authority in the country, so any contempt of itself, if left unpunished, could percolate down to the lower court sections, and that way the legal system would get undermined piece by piece. So even Prashant Bhushan had posted these two tweets. So the case was brought before him. However, the fine that was imposed, however, because he was such a prominent lawyer, the apparently maybe that, or just as a warning sign, but not to unduly punish him. I mean, it was just a couple of tweets. It wasn't like he did anything particularly bad. So the Supreme Court just imposed a symbolic fine mostly of just rupee 1. So what happened was, if the thing is, this fellow Prashant Bhushan was a very prominent lawyer, a very prominent legal authority in his own way. So since he was a prominent critic, and the Supreme Court deemed that his criticisms, if taken properly and if done in a proper context without any malicious attack, could actually be beneficial for the general, for law students and aspiring legal professionals, and even for the general public. So instead of punishing him badly, they just imposed a symbolic fine of 1 rupee, most like just to give a message that contempt would be punished, even if only minimally, that it would not be disregarded. So what happened was, in the aftermath of this case, there had been a public debate going on as to whether scandalizing the court should remain an offense. Now this is still going on. As it is, it's still there. The debate, I suppose, is still ongoing. Debates like this, it is very subjective, depends on case to case basis. Every case is different. It has its own matter, own circumstances. So this sort of public debate is probably never going to end. No, whether it be prominent advocates or even the low ranking ones like us. Of course, in case of those of us who are not so prominent, this sort of public debate wouldn't even happen anyway. But this Prashant Bhushan was prominent, so it happened, and it's still happening. It will continue on. It won't stop. Then another case was Delhi Judicial Service 1991. Now this, as I said earlier, what had happened was, in Gujarat, there had been a judicial magistrate who found that police officers working in the court who are under him, they were not issuing summons properly, not issuing warrants properly, that they were just taking cases too lightly. Essentially, they were neglecting their duties. So he had attempted to take some sort of action against them, and the police officers in response unjustly arrested him for doing his duty. And not only that, they had handcuffed him and publicly paraded him in a humiliating fashion, most likely as revenge, for most likely to exercise their petty power, and to try to as essentially a sort of message to the judicial magistrate to back off and let them carry on the way they were. Now, obviously, the Supreme Court did not take this thing lightly. The officers were held guilty uh, of abusing their powers, and by this punishment, the Supreme Court affirmed its stance on protecting all levels of the judiciary. Every legal officer, advocate, and all would get the protection they needed to carry out their duties properly without any harassment from police or any other connected people. So what happens was, what this case proved was that this case buttressed, strengthened the judiciary's independence. In a democracy, especially in our democracy, an independent judiciary keeps a check on the abuses of the legislature and the executive, ensuring that they don't pass unnecessary laws which which essentially oppress the members of the general public in any manner. That they either stop the laws or they pass judgments which ensure that those laws are invalidated. Like you could say, take a recent case of the central government. Okay, this is a little too sensitive, so I won't go into that. But I'm pretty sure all of you are aware of the protests that have been going on in major cities over an act pertaining uh, to the lower caste students being given more powers against discrimination in universities. So that pertains to this. The Supreme Court essentially passed an order stopping that law. So again, the Supreme Court could only do that because it was not dependent on the executive or the legislature that passed the law in any manner. So that's why they could stop this sort of law from happening. It remains to be seen what happens further, but for now, let's just say that's what happened. That's what happened. So, yes. So there is another case. It's called DC Saxena. DC is in 1996. There had been there was this advocate called Dr. DC Saxena, a very prominent one. So what happened was, the then Chief Justice of India, he had made some sort of accusation, some very some very baseless accusations, something that had no proof. That when a case was brought before him, he couldn't prove those allegations were true in any manner. So he was severely punished for this. So what this case established was, while you are allowed freedom of speech and expression, that does not mean you can just attack the court system or even prominent people in the judiciary in just about any manner you like. That no, freedom of speech and expression has its limits. Too much freedom of speech and expression could result in unsavory views becoming prominent, becoming strengthened, ultimately those views becoming so prominent that they become the law itself, undermining the so-called the liberty of freedom and expression which allowed those views to remain in the first place. A lot of tyrannies in the world took advantage of the earlier liberty provided to them, and they suppressed their liberty later on. So again, this case ensured that liberty was not unduly exploited. So essentially, this sent a message to the public that liberty of speech and expression is important, but at the same time, don't exercise it any which way you want, such that you unduly hurt the institutions that enable such liberty in the first place. As the English expression said, don't bite the hand that feeds you. That is what this case implied. Then when it comes to analysis of the case from a public perspective, what happened was, this so what are the benefits of this case from the perspective of the public? Number one, the authority of the judicial system is strengthened. The decrees and orders passed by them carry full weight and value, and it ensures that people obey those decrees and orders. At the same time, It also establishes the rule of law properly, ensuring order in the country. That said, there are challenges also. One is there is under criminal contempt there is a ground called scandalization of court. Now, as I said earlier, attacking the court in any fashion invites contempt. But what happens is there are judges, egotistical judges who think they are very important in the system. So they attempt to use this particular provision in the law to undermine potentially insubordinate lawyers and subordinate legal officers who they believe could oppose them, or even if they do pass criticisms which are perfectly reasonable, or if the judge deems unreasonable for any reason going on in his mind, the judges could use this provision to punish them, to suppress them. You could say this is not really implementing the law, or just that it is just some sort of petty tyranny and oppression. So again, when it comes to this provision, the debate has been going on as to whether to abolish this. Of course, it's pretty muddy. Abolishing the provision as a whole means that any courts could be scandalized in any manner whatsoever, thus weakening their authority and weakening the rule of law. But on the other hand, keeping the provision as it is means abuse of power by egotistical judges. So again, there is a lot of public debate going on about this. It's still ongoing. I suppose the solution lies in modifying the provision of law such that allowing for some criticism, at the same time ensuring it doesn't cross the line into malice. Again, this will take a lot of work, and for now we just, all of us lawyers have to be just careful not to criticize judges unfairly, or just to keep our heads down and survive in the legal system. Try not to unnecessarily attack judges. Just know your place in the legal system and carry on. Change will come, we don't know when, but it will, hopefully. Then there are legal advancements have been made in this law. One is as I said earlier, under section 13, you could state in a court that you are only presenting the truth of the matter in the interest of the public. That's a valid defense which has now been provided. Then obviously now with the onset of the digital age, there is social media and internet through which matters in courts often get publicized within hours and all. So again, awareness of this can be increased through digital means, through social media, through net and all. So again, there is a risk of this, namely, if, there is a risk of this truth as public defense. Obviously, what would happen is people would use this ground to publish just about any matter they feel is in public interest, even when it is really not so. So they could unnecessarily undermine the court's authority by publishing potentially compromising matters which were really better kept secret. So there is a need for a certain law commission to investigate this matter properly, to establish borderlines, boundaries for free speech, for truth in public defense and other matters. So coming to the end of this presentation, just to inform you all, just to state it simply, what I would like to advise you all, especially those of you who are in the legal field and all, is that try to keep your head down in the legal system. Try not to indulge in cowboy criticisms of judges and all just because it feels very daring and exciting. That excitement could really come to bite you. So try to survive in the system. Try to ensure that now try not to kiss your superiors. Okay, let me just say this more politely. Try not to unnecessarily please your judges, the judges or your superiors and all. At the same time, try not to undermine their authority unnecessarily. Just you could say keep a border, keep a line. Then when it comes to contempt of courts, try not to do it. Try to ensure that even if you do it, ensure it benefits not just you but everybody else around you. When it comes to court orders, respect the court orders. If you respect the court orders, others also will, and the rule of law is strengthened. It ensures that there is order in the country, and everybody knows what to do if things go bad, that there is no undue criticism, and that there is no warlike situation in the country disturbing the peace. That way it's important that our justice system, our judicial system, of course I would not go so far as to admit our judicial system is perfect. There are plenty of flaws, namely slow cases which are pending in courts for years, too much legal expenditure on hearings and all, the frustrating waits and all of it is bad. The judicial system has room for improvement and it should be done. But that doesn't mean we should resort to extrajudicial means. Extrajudicial means just makes matters even worse, because those are not means commonly agreed upon. Those are means that you think are better for you. It's mostly about your own grievances, not everybody else's. Working for the common good means working for our own good ultimately. If you undermine the common good, you end up undermining yourself further down the line. So my advice is to all of you, do your best to preserve the justice system. Try not to undermine it unnecessarily just for your own benefit. If you keep it if you help to keep the justice system stable and functional, at the end of the day it benefits you too. Just I said earlier, just to conclude this video, whatever benefits the public good ultimately benefits you. So work for the common good, you will be benefited too, even if it takes a while. So thank you all for watching this video. Please like this video if you can, and subscribe to my channel at siddharthbut4898 for more of my content, more of my videos. Thank you all for watching this video. Thank you.